Hello Dragons, and welcome to this instructional video for Lesson 11 Part 1, the role of the federal courts. The main idea behind this civics lesson is the judicial branch of the federal government interprets the Constitution and decides if federal laws protect the rights of citizens. Both state and federal courts resolve legal conflicts in criminal and civil cases. With that in mind, by the end of watching this video, you should be able to explain the need for laws and a legal system, describe the role of courts in our legal system, and compare the role of state and federal courts. Now that the outcomes for this lesson have been shared with you, let's get started. The judicial branch of the federal government is made up of the Supreme Court and over 100 other federal courts. The most important members of the judicial branch are judges. Although they work quietly, away from the hubbub of politics that surrounds the president and members of Congress, the judges of the judicial branch have a very important role in our government. In our society, disputes involving laws are resolved in the legal system. To understand the need for a legal system, consider the following example. A legislative body makes a law prohibiting one person from purposely damaging another's property. If a junior high student is then accused of throwing a baseball through someone else's window, several issues may have to be decided. Was the ball thrown on purpose? Has the law been broken? Is the accused person innocent or guilty? How shall the person who threw the baseball repay the person whose window was broken? These questions may be decided by the people involved in the incident, but if the matter is serious enough, it may have to be decided within the legal system. Legal conflicts in our country are resolved by courts of law. All courts perform the same basic function: to apply the law to an actual situation. Courts in our legal system resolve two kinds of legal conflicts. In a criminal case, a court determines whether a person accused of breaking the law is innocent or guilty. If the person is found guilty, the court also decides what the punishment will be. In a civil case, a court settles a disagreement. The disagreement can arise over such issues as who caused an auto accident or broke a contract, over a divorce, or over possible violations of constitutional rights. The federal courts hear both civil and criminal cases, and both kinds of cases can find their way to the Supreme Court. Every court case involves two opposing sides or parties. Who these parties are depends on whether the case is civil or criminal. The typical civil case is brought to court by a party called the plaintiff, an individual or a group of people who bring a complaint against another party. The party who answers a complaint and defends against it is called the defendant. The defendant may be an individual, a group, or a government body. Imagine that Mabel Edwards brought the Techno Corporation to court, claiming that the company had denied her a job because of her race. She would be the plaintiff in this civil case, and the company would be the defendant. The case would be called Edwards versus Techno Corporation. In contrast, a criminal case is always brought to court by the prosecution, a government body that brings a criminal charge against a defendant who is accused of breaking one of its laws. The prosecution is referred to as the people and is represented by a government lawyer known as a prosecutor. What if Arlo Ashley was accused of robbing a convenience store in Roseville? The state of Michigan would bring him to court on charges of theft. In a criminal case, called the People of the State of Michigan versus Ashley, Arlo Ashley would be the defendant. In a court, the job of a judge is to apply the law to the conflict between the plaintiff or prosecution and the defendant. This means determining which side's argument is most in keeping with the law. The judge directs the proceedings but must remain neutral and not take sides in the conflict. Many legal cases can also involve a jury, which decides the facts of the case, such as what happened and who did it. You may remember that a trial by jury is one of the rights guaranteed by the Constitution to a person accused of a crime. In the process of hearing a case, a court may have to decide what the law in question means. For example, does a law banning motor vehicles in a park also ban radio-controlled model cars? A court may have to decide if the law is allowed by the Constitution. This process of interpretation is an important job of the courts. Although the legal system deals with individual cases, a court's decision in a case can have very broad effects. This is because a court's decision can establish a precedent, a guideline for how all similar cases should be decided in the future. A precedent makes the meaning of a law or the Constitution clearer. It also determines how the law should be applied both inside and outside the legal system. For example, the court's decision in Brown v. Board of Education established a precedent that made any law segregating blacks and whites unconstitutional. Our legal system is made up of two separate but interconnected court systems, those of the states and that of the federal government. Although decisions that establish the broadest precedents are made in the highest federal courts, most legal cases begin in a lower court, often at the level of state government. To understand the federal court system, it helps to know about the state court system. Each state has courts at different levels of government and courts for different purposes, such as traffic courts and juvenile courts. All of these courts are considered part of the state court system. Since most of the laws that govern our everyday actions are state and local laws, most legal disputes and violations of the law are decided in state courts. The court to which a legal case first goes has original jurisdiction, the authority to hear a case first. A court with original jurisdiction determines the facts in a case. Often this occurs during a trial conducted with a jury, but in certain cases a judge hears the case alone. Because they hold trials to resolve cases, courts with original jurisdiction are also called trial courts. What happens if the court of original jurisdiction makes a decision that the plaintiff or defendant in the case believes is unjust? Then he or she has the right to appeal, to ask a higher court to review the decision and determine if justice was done. In each state, there are appeals courts set up just for the purpose of hearing cases appealed from lower state courts. These courts have appellate jurisdiction, the authority to hear an appeal. An appeals court does not hold a trial, nor does it determine the facts of a case. Its purpose is to review the legal issues involved and to determine if the law was applied fairly and if due process of law was followed. An appeals court may decide to affirm, or let stand, the lower court's decision. However, if it decides that the trial was unfair for some reason, it may reverse the lower court's decision. When that happens, the appeals court may order another trial, which is held in the court of original jurisdiction. When a plaintiff is declared innocent, however, the prosecution may not appeal because the Constitution prohibits double jeopardy, being tried again for the same crime after being declared innocent. The appeals process may go beyond the first appeals court. In most states, the final court of appeals is the state Supreme Court. Although state court systems differ, most have three levels: trial courts, appeals courts, and a court of final appeal. You will learn how state courts work in Lesson 13. If state courts have original jurisdiction over most legal disputes that occur in the United States, then what's the purpose of federal courts? Federal courts hear two kinds of cases: cases involving federal laws and issues beyond the authority of individual states. In these cases, the federal courts have original jurisdiction. These types of cases include cases that raise constitutional questions, cases involving federal laws, including treason and tax evasion, cases in which the federal government is a defendant, disagreements between states, disagreements between people from different states when more than $75,000 is in dispute, cases involving a foreign government and a state, cases involving treaties signed by the United States, cases involving American ships at sea, and cases involving ambassadors and other foreign representatives. The second type of case are cases appealed from state supreme courts. These cases must involve a federal law or a constitutional issue. They are heard only by the Supreme Court. The authority to hear cases appealed from the state court system gives the United States Supreme Court and the federal Judicial Branch the leadership role in our legal system. In this role, the Supreme Court sees that all 50 state court systems interpret the Constitution in the same way and that the rights of all Americans are protected. So that's the way it is with Lesson 11, Part 1, the role of the federal courts. At this point, you should know that there are two types of court cases, criminal cases and civil disputes. Both the federal government and state governments maintain court systems to handle both types of cases, and both federal and state court systems help interpret the law and determine how it should be applied. Don't forget to subscribe to my channel to have the entire catalog of civics videos available at your fingertips. Click the subscribe button and then click the follow bell to receive notifications as to when the channel is updated. Thanks for watching, and I'll catch you in class, Dragons.